Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to a special edition of our Curious Amalgam. My name is John Roberti. Today, we're going to talk about a recent and very interesting event. On January 10th, the U.S. Department of Justice and the Federal Trade Commission released draft vertical merger guidelines, and they were released for public comment. The vertical guidelines are important to practitioners because they provide direction on how you might deal with the agencies. And so we wanted to quickly get out some thoughts on on what these guidelines were going to mean. We're going to do a couple of things. I'm here today with my co-host, Sergei Zaslavsky. Sergei and I are going to talk a little bit about what those guidelines say. We're going to bring in a couple of special guests who are experts in the area to talk about what they mean, and we're also even going to listen to some comments from outside experts. So it'll be a great program. My co-host today is Sergei Zaslavsky. Hi, Sergei.
Hi, John. How are you?
Good. So, Sergei, tell us, what's important about these guidelines? Why should we care?
So this is a pretty big deal because I think the Antitrust Bar has been awaiting some new guidance on vertical mergers for a while. The last time the agencies have issued vertical merger guidelines was 1984, and it's pretty widely felt that those are now outdated. And there's not been much recent guidance from the courts either prior to the recent AT&T Time Warner case. The last time the government litigated a vertical merger to verdict was in the late 70s. So no big body of contemporary case law either. So some much needed guidance.
When we talk about vertical, one of the key issues is understanding theories of harm. Could you maybe just explain briefly to us, and this will be a key part of the guidelines, could you explain briefly to us, very shortly, what are the key theories of harm that are in the guidelines?
So there are three that are featured most prominently in the guidelines: foreclosure, raising rivals' costs, and access to competitively sensitive information. Let's say that I am a producer of a raw material that's used to manufacture a widget. I'm an upstream firm. And I buy a downstream firm that actually uses that raw material to manufacture a widget. You, John, are a rival downstream widget manufacturer. Now what I might do is I might say, John, you don't get to buy any of my raw material, and you don't get to make the widget. That's foreclosure. I foreclose you from competing with my downstream.
So foreclosure is locking me out. Okay, what's the second one?
Raising rivals' cost. I say, John, you can still buy the raw material, but I'm going to charge you twice as much, and you're not going to be as good a competitor now to my downstream firm.
Okay, so being mean to rivals. Okay, and what's the third one?
Access to competitively sensitive information. John, you can continue buying my raw material, but I know exactly how much widgets you're going to manufacture next year because I know how much you're contracted to buy. And now I'm going to tell my downstream manufacturer, John's going to manufacture 100 widgets next year.
So that exchange of information that may facilitate collusion. Okay, I got the three issues of harm. Okay, got it. So the third point is don't share information that could lead to collusion. All right, Sergei, so tell us, what are the three most important takeaways?
One, the inclusion of the quasi safe harbor in the guidelines. If my downstream widget firm has less than 20% of the share, and if my raw material that I sell is used in less than 20% of the widgets, agents say they're unlikely to challenge the merger. There may be exceptions, but there's a quasi safe harbor.
What any others?
Two is what is not in the guidelines. For horizontal mergers, there is a presumption that the government enjoys that if there's a merger occurs in highly concentrated markets, increased concentration, government gets the benefit of the doubt. There's a presumption that the merger will have anti-competitive effects. No presumption for vertical mergers.
And what's the third one?
Efficiencies matter. Big emphasis on efficiencies in the guidelines, both elimination of double marginalization and combination of complementary assets. I think it's widely felt that vertical mergers are frequently pro-competitive, and that viewpoint is certainly reflected in the guidelines.
Okay, thanks, Sergei. So now let's bring our two expert guests. They are the two co-chairs of the Antitrust Law Section's Merger Committee. We have Joanna Tsai. She's a vice president at Charles River Associates, and she is a PhD economist. And we have Mike Keeley, a friend of the Curious Amalgam and a partner with the Axon law firm. Mike, Joanna, welcome.
Thank you, John.
Amazing to be back.
It's great to have you on, guys. So, Joanna, tell me, what did you find to be the biggest surprise or the most noteworthy thing about these guidelines?
I think the guidelines is quite an achievement on the agency's part. I can see how difficult it may have been, to reach consensus amongst, on the FTC side, 3 commissioners. And of course, as we have seen that 2 commissioners abstained, in a guidelines like this, it always, involves a lot of discussions, in the, within the agencies and also across the agencies between the DOJ and the FTC. So I think it's I can see a ton of work that have gone into this. Now, my initial reaction upon reading the guidelines is that I was surprised to see the 20%. The 20% that Sergei, you mentioned as a quasi safe harbor. I was surprised by it because, number one, it's a lot of times in a lot of cases. It depends on the particular case, and it's very fact dependent, and it's very hard to, I think, nail down a particular number that means this deal is, not likely to substantially lessen competition versus this other deal is. So in terms of having that number in the guidelines, I was surprised to see it. And of course, you can imagine that, some might view this as too low and others may view this as, too high. So that's my initial reaction.
Now, Mike, Joanna talked about how analysis tends to be very deal specific, so it may be difficult to pick one number and say this is the threshold. What do you make of this quasi-safe harbor, especially given that the guidelines do leave a lot of wiggle room? They say that in some cases there may be competitive issues with a deal where the shares are less than 20%. Is this a real safe harbor? Does it give you comfort? Or is there enough wiggle room and enough deal-specific factors where you think the number is not that meaningful?
Oh, I don't know, and I don't want to be too pessimistic about it. I'm glad that the guidelines are out. I was actually surprised when they came out last Friday. In some ways, the bar has been waiting for this, like the last episode of Star Wars. Yeah. It's been talked about for so long, and it finally came out. So that's a positive. With regard to, and it was a lot of work, clearly a lot of work, as Joanna said. So kudos to the agencies for pulling it all together. In terms of the safe harbor, I think we'd all like to have bigger harbors. More boats can fit in bigger harbors. And so 20% is, definitely surprising. In Europe, the threshold is 30% for the safe harbor. And so in some ways, that's a little bit surprising. And that'll have consequences for how we counsel clients.
Yeah. That said, I just want to add, of course, there is a number that says 20%, but the guidelines does allow, in a sense, sort of, things going either directions. The guidelines, states that, of course, that doesn't mean that shares greater than 20% necessarily means that the deal is, anti-competitive. But on the other hand, it also means that, shares of less than 20% doesn't mean that it means it's unlikely that it would be anti-competitive, but doesn't fully rule out that it could be anti-competitive.
So we're talking a lot about market shares right now, which is interesting because in the last edition of the Horizontal Merger Guidelines, 2010 guidelines, I think they tried to reduce the emphasis on market definition and market shares. I feel a lot of economists feel that generally competitive effects are more important than just defining the market and finding the market share. And I'm curious, in your reaction as an economist, Joanna, do you think that these guidelines will actually increase the emphasis on calculated market shares due to this quasi-safe harbor, and whether that's taking analysis in the right direction or if people should be more focused on competitive effects?
That's a great question, Sergei. I think there could be an increasing emphasis on market definition for the reasons you stated. I mean, as an economist, I've never fully ignored market definition. I think, whether or not, you define a relevant market by, going through a hypothetical monopolist test, a SNP test, to get there, it's still an important step in the analytical framework to lay out and identify, potential competitors, potential competing products and services. And that is also informative in the estimation of competitive effects. So it's part of the analysis is from my perspective. Now, moving on to the vertical mergers guidelines and how it is described there, I agree. Yes, I mean, in order to get the 20%, we need to know what the denominator is, and therefore what that market is. On the other hand, that is not the end-all be-all, because as the guidelines go on to say, you are still essentially looking at the effects, and that's how it is laid out in the unilateral effects section of the guidelines, where it goes through these 4 points, that talks about what are the ways in which competition could be substantially lessened in that vertical context.
So you think there's a balance that's more or less right. Market definition obviously still matters, market shares still matter, but people look at effects beyond just market shares. That's my reading of the guidelines. That it's consistent with, in a sense, symmetric with the horizontal merger guidelines, where we talk about the presumptions you mentioned earlier, the shares and the HHIs and the change in the HHIs, which is based on some sort of measure of market, right? But then also discussions of things like the upper pricing pressure that's meant to estimate the effects, and similarly, in the vertical merger guidelines, they talk about the 20%, and then they also talk about the actual effects. Now, Mike, I know you counsel clients a lot about mergers. Let's say a client came to you day before these guidelines were issued, and then a client comes to you a week after the guidelines are issued. I imagine one thing that's going to be different is now, in terms of how you advise the client, is now you're going to try to figure out, well, is your market share above or below 20%? That's obviously something that's given more importance now. Anything else that is different in how you would counsel a client in light of the release of these guidelines?
It's a great question, and we'll learn more as we go along, assuming the guidelines get adopted finally in the form that they are. When you're dealing with merger guidelines, which are very helpful to have, you are looking for a way to engage with the agency and explain to them why they can quickly clear the deal and to get comfortable that there's not a problem. And so I think with the safe harbor at 20%, a lot of work will be done to try to build up a set of advocacy for the agencies to show, yes, we're under 20%. And that might mean more work on market definition up front than we might have previously done in the context of a vertical merger. And going back to what Joanna was saying, I mean, one of the fascinating things about vertical analysis is it's a little bit more squishy than, to use the technical term, than horizontal merger analysis and the guidelines. And so, what can we rely on that's concrete? Well, market share. We can rely on that. And so I think a lot of work will go into trying to squeeze into that safe harbor if you can.
And you mentioned that obviously these are just draft guidelines, and we'll have to wait and see what the final version will say. Now, it's very unfair to ask people to predict what will happen in the future, but I'm going to be unfair. If you had to predict the final version that we'll see after the comment period, do you think it will resemble this version pretty much very word for word, closely? Do you think there'll be slight changes around the edges? Or do you think we might see any big changes come out as a result of the comment period?
I think there'll be some changes. I think there's a lot of people working on comments, and a lot of very smart people on the M&A committee. We have 3 of our vice chairs who are banging away: Michael Gleason and January Kim and Paul Wong. Shout out to them for the hard work of putting together really high-level comments in a short period of time. They're cooperating with some other folks in the section on comments, and I'm sure comments will come in from public interest groups and antitrust groups. I'm sure AAI will make comments. And so I could imagine there being some changes, but getting to consensus was probably pretty hard between the agencies, and so this is probably what we're going to get by and large.
John, do we have a video to play as well?
Yeah. So apropos of Mike's comment, we the merger committee at the Antitrust Law section has been contacting stakeholders, people who have commented, might comment, to ask for reactions to this. We're going to be collecting these reactions in videos, and we'll be posting them on the website. But it's really terrific. We've actually got one in already from the American Antitrust Institute. The executive director, Diana Moss, another friend of our Curious Amalgam, has put together some thoughtful initial reactions, and I thought we might play that and then listen to her and then discuss some of her comments.
Many thanks to the Antitrust section for inviting me into this lightning round of reaction to the new vertical merger guidelines. This is a commendable joint effort between the federal agencies. We badly need vertical merger guidelines, and the importance of agency guidance in providing transparency and predictability about law enforcement really can't be understated. On substance, here's some food for thought. First, the guidelines incorporate agency learning and advances in scholarship, but they could do more to reflect evidence from large consummated vertical mergers such as in healthcare, agriculture, and communications. The evidence strongly supports the need for more clearly defined presumptions for when a merger is illegal. And that is when high concentration in upstream or downstream markets supercharges incentives to foreclose rivals or facilitate anti-competitive coordination. Second, the guidelines strive to answer questions and provide clarity. But here, the agencies might consider the implications of a few things. One is giving the elimination of double margins center stage in the discussion of benefits of vertical mergers. It's even got its own section, separate and apart from efficiencies. EDM is a key issue, to be sure, but if the agencies are going to give it that much airplay, it seems we should see a corresponding shift in the burden to prove EDM to the merging parties. A second issue is that we can't find any discussion of 2 really important elements of vertical merger analysis. One is the role of multi-level entry in offsetting concerns about anti-competitive effects, and another is how a merger can harm competition through regulatory evasion. Both of these issues are as, if not more important now, as they were in 1984. And finally, the guidelines incorporate by reference many elements of the horizontal merger guidelines, a good thing. But those connections appear to be loosely defined in some cases, which could create some ambiguity that wouldn't serve the purposes of the guidelines more generally. Just some food for thought. We think this is a good start to a process that should ultimately, through a process of public comment and debate and revision, produce guidelines that will be extremely important in promoting strong antitrust enforcement. Thank you.
So for a little bit of background, Diana is with the American Antitrust Institute. I should have said they are a think tank, a research organization that focuses on encouraging enforcement of the antitrust law. So this is a pro-enforcement group, and some initial reactions there. Sergei, what did you think?
Some very interesting reactions and obviously an interesting viewpoint. One thing that Diana talked a lot about is efficiencies, elimination of double marginalization. Joanna, I was wondering if you could explain to the listeners what elimination of double marginalization, or EDM, is.
Sure, I would be happy to. So EDM, as you explained, is elimination of double marginalization. A simple way to think about it is, this is an elimination of double markup. And so, as the guideline explains, in vertical mergers, we're talking about mergers between, two levels of the supply chain. And so normally, for each of these levels of supply chain, firms will profit maximize, which means that it will, take a markup above cost. And so it does this at two separate levels of the supply chain. So when the merger occurs, it's expected that it's likely that there will just be one markup as opposed to two, and this would then lead to lower prices.
Joanna, just to use an antiquated term, is it basically eliminating the middleman?
Yes, in one way, yes.
And everybody saves when you eliminate the middleman, so it's pretty intuitive why that would be a good thing. And as Diana mentioned, they get a whole section to themselves in the guidelines. What do you make of that section? What do you think about the guidelines treatment of EDM?
I think it's useful. I mean, in implementation, in practice, this is something that, I go into the agencies and I have conversations about the EDM with the attorneys and the economists there. And we've, I've certainly, implemented, estimates of the EDM in relation to deal work. So I think it's useful that the guidelines outlines, why, this could drive prices down as a downward pricing pressure as a result of the merger, as opposed to, any upward pricing pressure as a result of the merger.
And one of the things that Diana brought up is whether there should be clarity on who bears the burden on efficiencies, on elimination of double marginalization. Now, I read the guidelines to suggest that it's still up to the merging parties to explain to the agencies why elimination of double marginalization should be taken into account. Mike, what's your view? Do the guidelines provide some clarity about who bears the burden, or is it a little bit up in the air?
Well, I predict that a lot of the commentary that's going to come in is going to be around that EDM section and whether a burden should be assigned one way or the other. I thought the draft as it was written, whether it was intentional or not, is basically trying to have it both ways, not assigning the burden to the parties, but saying that the agencies expect the parties to point these things out. I think the key on EDM, and this goes back to counseling clients, is we need to be able to make predictions. And one of the things that is generally accepted in economics is that vertical mergers will result in this elimination of the double margin and give you a tailwind to convince the agencies that generally these vertical deals are pro-competitive, which has been the common understanding among most people for a long time. And of course, there are exceptions. So I think combined with the smaller safe harbor, chiseling away at the presumption that EDM will happen makes it harder for us to counsel clients that deals that we think are pretty obviously pro-competitive will meet little resistance at the agencies. So that'll be something to watch. What happens with the treatment of EDM? I am happy to see it in its own section in the guidelines as opposed to lumped in with the efficiencies section. As we all know from practicing, efficiencies are never decided early in an investigation by the agencies. It's basically we'll look at efficiencies, and I don't mean to disparage the agencies by this, but we'll look at the efficiencies if we have to in a deal that's a close call. And I think EDM is something we should use to say, look, this deal is it's not obviously anti-competitive. There's going to be EDM, and so you should let it go.
So you feel that EDM kind of plays a more important role than other efficiencies in agency review, and that the guidelines emphasis on EDM kind of reflects existing practice in that way?
I do. I think EDM should be presumed to occur, and if there are exceptions where it's not the case, that can be discovered by the agencies, or if they have questions, they can ask. Well, why isn't there something here that suggests that the saving is not going to occur, as opposed to requiring the parties to approve it in the 99 out of 100 cases where it is going to happen.
Now, when we started this conversation, when I was talking with John, I mentioned the three main theories of harm that were mentioned in the guidelines: foreclosure, raising rivals' cost, access to competitively sensitive information. Diana said there are a couple other theories of harm that she thinks are important that were not mentioned in the guidelines: multi-level entry and evasion of regulation. Could you briefly talk about those theories and discuss whether you think there's any significance at all that they're not mentioned in the guidelines, given the guidelines clearly say that their list is not exhaustive, so agencies may consider other theories even if they're not identified by name?
So despite the fact that you're looking at me, I'm going to punt this to Joanna.
Joanna?
So I will just say this. I think that you're right, Sergei. The guidelines, mention of foreclosure and raising rivals costs specifically, and the sharing of confidential information and all that. And as you very well explained, at the beginning, here are the ways in which these effects could be detrimental. On the other hand, the ones that they did not mention, I think one of the reasons that they're not, it's possible that they're not in there because in the agency's experience, perhaps they don't come up or they haven't come up as frequently. And that is not to say that, they'll never come up. I think it's just they're giving more attention, to the types of theories that, they've seen more frequently in practice.
That makes sense. If you're going to highlight three by name, you would highlight the three that come up most often, and then you leave the door open to consider some of the more esoteric ones that might come up once in a while.
Correct.
That makes sense. Any other reactions to the merger guidelines that you would like to get out on the air before we wrap up?
Just one, and this goes hand in hand with the safe harbor point that we made, which is one of the biggest challenges that we're seeing now is not just predicting whether there will be a concern about a vertical issue at the agencies, but whether or not we can come up with a remedy that will address it in cooperation with the agencies. And I think with the increased skepticism at the agencies in the U.S. Around behavioral remedies, it is sort of a double whammy, where if you have a smaller safe harbor and also less certainty about whether or not you can achieve a behavioral remedy as opposed to a structural remedy, it just adds to the uncertainty. So I'd be curious to know whether the agencies at some point will put out some more concrete guidance about when they will accept behavioral remedies and when they won't. I know it's been a topic of great discussion, and I think more clarity on that will help make sure that we can counsel clients on vertical transactions in a way that is reliable.
Do you think that's something that actually could be addressed in the vertical merger guidelines in the final version, or do you think that really deserves its own separate guidance?
Well, I think it could, but I think we'd have to wait for 3 more Star Wars movies for that to be completed.
Joanna, any final thoughts?
Just one, since we have just a few minutes left. But I wanted to mention that I thought it's in the guidelines, the agencies talk about how, when we employ economic models to simulate the potential, effects, unilateral effects that may result from the merger. It specifically talks about how it's important that such simulations, would, point to, would consistently point to a price effect, as opposed to, situations where you might imagine, given certain assumptions, you end up with one scenario where it would lead to a price effect. So I thought it was very good that the agencies included that, and it, in practice, I think that's very consistent with my experience as well. We never, as economists, on both sides, either at the agencies or, in consulting, we would never want to present models and results that, that only generate that type of conclusion when you have a specific, set of assumptions, and it's always a good idea to look more broadly to make sure that your conclusions are specific to just one set of assumptions.
So it reminds both sides to focus on empirical work and models that are robust to changes in inputs, changes in assumptions. You can't just specify a model with a particular set that gives you one result and say that's it. You have to make sure that it's really robust and to reasonable changes in assumptions and inputs.
Absolutely.
So I have a question. I think maybe this is mostly for you, Joanna. I read the guidelines. They say draft vertical merger guidelines released for public comment. So I know you worked in the front office at the FTC. Is the next step here that folks are going to be weighing in and commenting? Is that how it works?
Sure. I was in a commissioner's office. I was economic advisor to Commissioner Josh Wright. So, yes, I mean, this is a comment period. This is a draft. I think the agencies are very clear about that. And there is a comment period that ends, a few weeks from now. And then the agencies will review all of these comments in earnest and discuss whether any of the changes or suggestions should be adopted into the final guidelines.
Well, great. So we'll continue to follow these comments as they come in. And Mike and Joanna, can we invite you back after we get the comments and we learn more about whether these guidelines are going to become final?
Absolutely. I'll come if Joanna will come.
And I'll come if Mike will come.
All right.
Well, in that case, we'll look forward to having you both back. Thanks again for joining us, and we'll see you again next time.
Thank you for
listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.